And this is incredibly important because this, in actual fact, could potentially prove apparent bias. And in the court of law, you do not need to prove necessarily bias. In actuality, in actual fact, you need to, well, let's look at the law on this, or the legal test. And the legal test is this: would a fair-minded and informed observer, having considered the facts, conclude that there was a real possibility of bias? And before anyone asks me in the comments, because you guys always do, this test is applied in England and Wales. So a fair-minded person would say, well, why were the words of course used? Why were they used? What evidence supports the idea of this was inevitable so that the judgment could use the words of course? And then if you're going to go down that road, it could potentially be a little bit of a slippery slope, because this is now an assumption about my character rather than a factual finding. We could even say, would the same assumption be made towards a non-disabled person? Well, let's just think of the video that we've seen in this video that I've shown you, the video of Miss Nye. We can see nowhere in the judgment does the tribunal refer to her refusing to, inform HR as being rude or even obstructive, perhaps. Words like that are not used. And the words, of course, Miss Nye would refuse or refused to inform HR because the claimant had raised a grievance against her. I mean, nothing, if we look at it from both sides, we can see that there is definitely a singularity of language use. Now, where this goes even further is a grievance that we are talking about here was a grievance that related specifically and directly to disability. So the grievance in itself was a protected activity because of disability under the Equality Act of 2010. And if you were to look through the near 1,000 paragraphs of the judgment that is publicly available online of this case currently, I'm saying there is I'm hoping to have various things changed and challenged, obviously, because of very simple things like this. But what we're looking here, when we look through all of these paragraphs, in particular when I read them, is that I find that the judgment criticises me incredibly in tone, in attitude, and in my credibility. And all of that contributes to an appearance of a prejudgment. Because tribunals in particular, when they are dealing with disabled claimants or disabled litigants in person, people like myself that have self-represented through the entire case, the tribunals are meant to ensure that there is a complete, that power imbalances are definitely addressed, that responses do not cause distress, and trivializing protected acts like having the legal right to raise a grievance against an employer for their failure to make reasonable adjustments or bullying or harassment because you've requested reasonable adjustments is reinforcing stereotypes, and one might even say is incredibly discriminative, because what it does effectively is it undermines completely the neutral aspect of the Equality Act and what it strives to protect. Now, I am not saying, to be very clear, that the judge was biased. I'm not saying that. I'm just raising points of concern over elements of expression and what they could potentially mean when they are used in certain ways. Because the minute we open our mouth, we release words, and I believe very much we are a slave to our own words. And judicial language in particular, where one goes to have what they believe is a wrong corrected legally, and we would expect that judicial language suggesting inevitability can undermine the appearance of neutrality and being neutral and equal and fair and balanced. I don't know. Let me know what you think about this point. And as you can see, if you go through the judgment and you really start looking at what's been written and how it has been written, it's quite interesting. And she subsequently made it clear that she did not want Miss Nye dealing with her disability issues. This does not, we find, excuse the rudeness of the claimant to Miss Cook, who she knew had only been assigned as her line manager on a temporary basis whilst Miss Nye was absent during December 2021. So Miss Cook had been assigned to be my manager, so she would have had a handover from Miss Nye, and I was being told that I couldn't do this, and that if I go on, why wasn't I at work, because I'd been put on a course. And I responded, well, haven't you had a handover? You like the manager, my other manager, Miss Nye, signed me off on this course. You should know that I am signed off to go on a course. You should know that information. And for me, I felt, well, that's not my failing, that's yours. And again, because of like some of the conditions that I have, I'm very literal. And I think sometimes people think that it's like without filter, particularly ADHD, people with autism, your whole character gets totally, and the things you say, completely missed. So this is a really, really good example of disability related behaviour being misattributed as rudeness rather than recognised as an actual manifestation of disability. Now, if you're involved in a situation with a work coach or an employer or even a tribunal, and this type of misattribution continues to happen, it can actually have really serious effects on what it is that you're trying to argue, or the outcome you're seeking, to have. Now, for me, in this particular instance, I would definitely be arguing Section 15 of the Equality Act 2010, that, that is discrimination arising from disability, that doing this by mischaracterizing somebody's behavior, which is literally because of their disability, is treating them unfavorably. And the reason for that, if you're suffering from stress and you're suffering from anxiety, or you've got PTSD, or you've got any of these other conditions, these are things that you cannot necessarily control. So to treat you unfairly because of it, to say you're being rude because you're being this, you're being that, is treating you and putting you at a disadvantage. And when it goes further, and when disability related behaviour is treated in a sense as misconduct, then that automatically engages Section 15 of the Equality Act, as I said, discrimination arising from disability. Now, another really interesting point to know here about the Equality Act is Section 20 and Section 21, which in this particular instance would encompass failure to make reasonable adjustments. Now, lots of people think if you have a disability, the reasonable adjustment is, a desk or a certain chair or, an aid or a walking stick, but it isn't always just that. Now, the Equality Act states that when a disabled person is put at a disadvantage, and in this instance the tribunal, the tribunal are mandated by law, by the Equality Act, to take reasonable steps to remove that disadvantage. And by saying I'm being rude is not, in my opinion, removing that disadvantage, it's mischaracterising it. And this is something a lot of decision makers do in the system, so know this. When an organisation, an employer, even a tribunal know that you are disabled, but still assess your behaviour in particular against a criteria of someone who is non-disabled, using that as a benchmark for a communication standard, they are not adjusting expectations, process, or even their interpretation, and that there is a failure. So the failure of reasonable adjustment potentially could be right there, and I most definitely would argue in this example that it definitely is. That is a failure to adjust the lens, not just the environment. So reasonable adjustments aren't always just about actual physical things that you can have and touch, and they're also about the environment that you're in and the perception of your disability. Now, there is one other potential element that could be useful. I'm not saying this is relevant here. I'm just using this as an educational example. So section 26 is obviously harassment related to disability. So let me explain a little bit more about that, because this one's a little bit more nuanced. Now, what the law says is that harassment occurs when somebody is receiving unwanted conduct or having unwanted conduct forced upon them. And the effect of that conduct is some of these things here. They violate you, or they violate your dignity, or they create an intimidating, hostile, degrading, humiliating, or offensive environment. I in particular do think when people refer to my behaviour as being offensive, because I'm quite direct. Being clear-cutting and factual is not offensive. That's just how my brain works. And then obviously if I'm under extreme pressure and stress, I just have to stick to the facts, because otherwise I will not be able to deal with things very well because of the effects of the other things that I have as a disability. Now, whilst I was working at the Department of Work and Pensions, I actually had that particular manager and another manager turn up at my front door and do a home visit because they said I hadn't logged on to work, when in actual fact I had logged into work. And they were also hiding round the side of my house, one of them was, which I thought was really quite harassing. I think, why would you do that? Why not just come to the front door along with the other people too? I also live opposite a small school. So when I have 3 full-size adults screaming and banging on my front door, not only did I find that incredibly harassing, but I found it very humiliating, and quite frankly, I was just so embarrassed because, it was like school drop-off time and everyone's looking at my house going, what the hell's going on there? So I think it's very, very clear and fair to say that it was definitely a humiliating and definitely a degrading experience. And the cherry on the top of the cake was that was actually on World Mental Health Day. Now, the 3 managers that were banging on my door, making out that they were so wanting to be so helpful, one of them was the lady that we've just seen in that video. The other 2 refused every single one of my reasonable adjustments, including disability trigger points, the entire time I worked at the Department of Work and Pensions. So I think I can quite safely say with hand on heart that they were not there for my best interest, and they weren't there to make sure that I was having my disability rights, because they had failed, in my opinion, to provide them in totality. So why were they there? Was it because I had made complaints about their failure to not do what they should have been doing, or with regards to disability rights and all the rest of it at work? I believe so, yes. So because of that, because my complaints or my grievances against them at work were because of my disability, it is my belief that the reaction to that was to, come and bang on my door and lord it over me and try and humiliate me and feel like I felt. Now, what's really crucial here, and what is very crucial, particularly in a court of law as well, is that when Section 26 is engaged in the Equality Act, it doesn't matter what the other people say. They can say, oh, no, I didn't mean to do that, and no. But it's actually how it makes you feel. So Section 26 can be engaged even if intent is denied. And it's knowing how to prove that and frame that in a logistic sense for a tribunal, for a job centre, for a PIP assessor. And you can, of course, you can use a solicitor, of course you can do that. But sometimes just being able to formulate this in a simple letter, in a simple document, can be very helpful too. And again, use Justice Writer Pro to do that. Because Justice Writer Pro has been with me throughout my entire case. It's helped me win 2 of my cases against the Department of Work and Pensions. It's helped people do an awful lot more. And as I said, this is not legal advice, but if you have experienced certain things and you want to have it recorded and written in a certain way that is factual, so that you can maybe raise grievances, make complaints, keep very good notes for tribunals or other meetings and things that you are going to have, then it's a really good tool to have literally in your pocket, because you can access it on your phone, on your computer, wherever. And I want to leave you all with this little shred of hope. Judging a disabled person's behaviour against a non-disabled norm without adjustment is exactly what the Equality Act of 2010 is designed to prevent. You have rights. Your voice can be heard. Do not let people do this to you just because you have a disability. It's because of your disability that you should not accept this type of treatment. It is unlawful, in my opinion. And being treated in this way for many months or many years can have profound effects, not just on your mental health, but also in other things in your life as well. That's it from me today, guys. I hope it has been helpful. It's been a long one. It's been a bit of a deep dive, but I'm trying to bring in various aspects of things that kind of like make sense and break down really complex things that are just not that easy to put your finger on and help you out. And I hope it has. Take care, and I will see you in the next video.